Hello, everyone, and thank you for joining. My name is Silvan Jongerius, and I'm the founding and managing partner at TechGDPR, a consultancy based in Berlin, specialized in GDPR, AI compliance, and privacy regulations for technology companies. My background goes back for about 20 years in the tech industry and about 15 years in senior leadership roles such as CTO and managing director. And I worked at the intersection of technology, data protection, and compliance. At TechGDPR, I focus on helping organizations navigate complex regulatory frameworks like the GDPR and AI governance, ensuring compliance while supporting innovation as well. With founding TechGDPR in 2018, I combined my passion for data privacy with deep technical expertise, helping organizations navigate complex regulatory landscapes, integrating GDPR compliance and drive business success. I hold key certifications, including the CIPPE by IAPP, the CIPT, Certified Data Protection Officer by the German TÜV, and I'm recognized as a Fellow of Information Privacy by the International Association of Privacy Professionals. Beyond TechGDPR, I also serve as the co-chair of the IAPP KnowledgeNet Berlin chapter. My expertise spans mostly data protection strategies, decentralized systems, and compliance governance with a focus on aligning technology and regulation to foster trust and innovation. So welcome to today's webinar, where I have the absolute pleasure of introducing Stewart Haynes. It's a privilege to introduce Stewart, who recently joined TechGDPR as a senior consultant and is a renowned expert in data privacy, compliance, and risk management. Stewart brings over 20 years of high-level expertise, including serving as the interim information commissioner for the Isle of Man, where he led national-level regulatory oversight and data protection initiatives. Stewart held prominent roles such as the Global Group Compliance and Data Protection Officer at Vista Global Holdings, where he built and managed international privacy governance frameworks for a multi-billion-dollar private aviation company. He also served as a GDPR consultant at The Body Shop International, implementing global third-party IT security and vendor risk assessments. Additionally, he held senior compliance roles at Adventis, the pensions regulator in the UK, managing data protection frameworks, AML, sanction compliance, and risk intelligence. Stewart's expertise spans GDPR compliance, DORA readiness, AML, and sanctions, making him a versatile leader in navigating complex regulations environments. At TechGDPR, Stewart joined to lead client projects on emerging technologies, helping business align compliance with growth and innovation. His extensive credentials include certifications such as the CIPM and of international compliance certification. Please join me in welcoming Stewart Haynes to today's webinar. Welcome, Stewart.
Thank you so much, Silvan. Thanks for the warm welcome. Thank you.
Now, we are ready to get started, and we promised you a nice package of insight beyond the, or basically behind the curtains of the regulator, lifting the regulatory curtains. Before we get started, I would want to ask everyone or invite everyone to join in asking questions in the chat. And if we find questions in the chat, we'll try to find time to answer them at a later point in time in this webinar. If you feel like you have further questions beyond the scope of this webinar, you can always reach out to us through LinkedIn, through email, through the usual channels. So let's get started. And I think I have a very interesting question that many people are very curious about if they work with regulators. And one of the moments that you get in touch with a regulator is when you have one of the unfortunate events of a data breach. And what I'm really curious about, Stewart, is what happens within the regulator the moment that a breach report from a company is received.
Sure. Thank you, Silvan. Thanks for the introduction as well. I think that's a really interesting question. I think I wouldn't want to answer for every statutory authority, every data protection authority. I know certainly as sort of the head of one previously, I can sort of perhaps lift the lid a little bit and say a breach report's probably looked at within an hour, I would say. So if people think that they're reporting and it goes into some vacuous hole where, it's looked at a month later or 2 months later, that's really not the case. And I think, I think regulators would be kind of, there'd be a disapproving look if regulators did that, especially, require and what they do of businesses. And I think it's important to know that there will be some initial triage of that report. So we'll be looking at likelihood of the event, the severity of the impact of the event, and not really culpability at that stage. It's really, yeah, as is the case with data protection, it's all looked at from the risk lens of the person, right? So not from the business, not looking at necessarily culpability at that stage, but looking at what's happened, how severe is it, how much is it multiplied by people, looking at kind of culpability a little bit later, more about containment really, and what have you done since reporting to us or since reporting to the regulator, what's happened, what have you actually done?
So what I take away from that is that is that of course the risk of the breach itself is addressed and assessed, but also has the company taken appropriate measures to contain the breach so far, and you also would weigh that in as a regulator.
Yeah, insofar as possible. So sometimes it depends on how companies report. And I would encourage people to be, or companies to be, very kind of, I'd say very open and I would say very open and transparent is what I mean. Rather than kind of shielding it in, kind of a spin, if you like, or we did this, actually get to the nub of the point, the nub of the risk, because it's quite clear when you're looking through a breach what's happened once you assess, through pages and pages of what might be mitigating actions, but actually, be really kind of factual about what's happened, what you consider the likely impacts to be, and be as kind of engaged as possible with the regulator. I think it's really important to not feel like you can't approach the regulator. I think it's important to understand what the threshold is to approach the regulator and what that might look like. And also, I think really it's kind of about making sure that your report is kind of in the interests of the people that you're actually reporting about, rather than necessarily protecting the business risk.
That's a really interesting point. From my experience, sometimes if we work with clients, there seems to be a certain hesitation in being transparent about the circumstances of the breach. Have mistakes been made by the company? And
Oh,
and from my experience on the consulting side, I typically take the approach of like, let's be transparent. Let's admit
oh,
that
yeah,
small mistakes have been made. Like there are humans in the room, humans make mistakes. That's what happens. But let's focus the attention on how it has been mitigated. And I think another reason for doing that, for maybe not being very transparent all the time, is that companies are afraid to get fined because of a
yeah.
data breach.
I
So
see that. I used to see it regularly. The kind of responses you get are sort of how can we cover ourselves here? How can we make sure we've headed off? Which is fine in a business context. I understand that regulatory attention is regulatory risk, is legal risk. I understand that, but actually you're looking at a very different risk and a very different type of risk. You're looking at a risk. You're reporting a risk not about what risk there is about for your business. You're reporting a risk about other people's potential harms that might come to them because of a particular breach. Now, what you really need to be drilled down on is what is unlikely and likely, and what's high risk and what isn't high risk. Now, that's where the nub comes. It isn't really doesn't really come in terms of getting sort of defensive legal advice, which might push something to a regulator, which might satisfy a requirement. But actually, once you go through that as a regulator, you kind of see it's quite open to see what the risk is. It's quite open to see what you're reporting, and that sort of effort is a little bit wasted, really. I've got to be honest. It's kind of you may as well go in exactly as you're required to, report what you need to, and ask for advice and help. I'd say there's on the flip side, I'd say you as a regulator, you can perhaps receive multiple kind of reports which don't need to be at the regulator. Now, there's the question of regulators there to help you and guide you. But I have thought myself once doing that role that do they grasp the essence of risk in terms of data privacy? Are they report everything to us, which in a way is a little bit of a risk factor in itself, is that they don't understand what risk is. They're just reporting every breach. So every email that goes astray, which there's no risk about any sort of there's no likelihood of harm or detriment to the person, but they'll report it to the regulator. You kind of think, are they fully in grasp of the sort of regulations here and what's their compliance obligations are? And it kind of it can open up a little bit of a Pandora's box in terms of you think, well, if we're getting everything, why don't they sort of grip the regulation? I totally get when companies want to get advice about a breach and to sort of have further sort of commentary from the regulators, but when you receive things that don't need to be reported, it does raise an eyebrow.
Right. That is quite interesting. I mean, on one side, it may be over flooding the systems of certain regulators as well. But what would be consequences of that? Would you, in that case, look and investigate if a company has a fair idea about risks?
Sure.
Is that your
Sure,
concern
sure.
there?
Sure. Not really. It's kind of, especially if you've got a DPO in place that's there to make sure they're that filter between you and the regulator and the data subject. I always used to say to the DPOs in the Isle of Man, you're an extension of the regulator. You're the eyes and ears of the regulator. You're doing the same job as us. You're there. But also, if you have a DPO in place and there isn't that filter, it means that either it's not being interpreted correctly how the law what requires you to report. If you just report everything, where is there any, where is there any need for a DPO if you report everything? Because there's no sort of filter, there's no risk assessment, right? Because you're de facto kind of reporting everything. But I wouldn't necessarily say that you shouldn't report things to the regulator. I think you should, but just be mindful of the fact that if you come to the notice sort of reporting everything and having no kind of assessment criteria or no kind of risk assessment of the things you're reporting, that might tip the scales in another way. So, well, actually, if you don't know about that, if you don't know how to assess a 1 in a million risk as being likely or unlikely, then you know how much of your framework is valid.
Right. Right. Maybe we can talk a little bit about when a company would be fined following a data breach. Of
Sure,
course,
sure,
that's
sure,
a
sure.
that's a that's a long process, and looking at like when is a company at fault, which I would presume would trigger a higher likeliness of a
Sure, sure,
company
sure, sure,
getting
sure.
fined, because of course there are like very sophisticated groups of hackers that can breach all kind of data. This is not something that you can 100% protect against. So how do you then apply that judgment as a regulator?
I think really it's a hard test to give a sort of generic response on that, Sylvan. I think it's very much case by case, which it should be. So it should be case specific. And I think every breach is by its nature, it's different in some aspect. So you can draw parallels to different breaches. You can say this is about missent email, or this is about a cookie breach, or this is about this, or this, or this. But actually, once you look at the detail, I think quite rightly things are scrutinized and matters are looked at in the depth of detail you'd expect and you'd hope as a person reporting or a company reporting. You wouldn't really, coming from the other side as well, I wouldn't want to be having a broad brush chucked at whatever I put in the regulator and put into one bucket and said, oh, you're this. Actually, people are diligent. They look at the nuances of the reports, and I think that's very important. That can take time as well. Regulators aren't required to give like an enforcement action as well. I think that's important for data subjects to understand is that you aren't forced, your hands aren't tied to make sure that you enforce against a company because it might not be appropriate. And it might be appropriate in other circumstances. And I don't want that to sound too wishy-washy, but really, I think it comes down to that case-specific sort of basis that you really need to look at every kind of breach individually. And I think that's how, as a regulator, you require companies to look at things, and quite rightly, that's how you look at things that are reported back to you.
Right. Maybe I'll follow up with a question in the chat right now that I find quite appropriate on
Sure,
this.
please do.
A question from Joao is like, what key factors differentiate companies that manage data breaches successfully from those that struggle? Are there certain things that
Yeah,
we
great
consider?
question. Great question. I think it's about really having those. I don't want to talk in management speak or anything like that, but I think it's about having the structure in place, the foundation in place to start with, right? So I think if you try to unpick a breach um, after not having had any kind of sort of data protection framework in place, and you know reach out to sort of tech GDPR on that. If you have no sort of structure in place, we can certainly help with that. But I think if you're trying to game the system, almost sort of like wait till a breach happens, you're really on a hide into nothing because it's really obvious straight away. Documents are timestamped, emails are timestamped, everything that a regulator will require to kind of see whether or not you had competence or you had even some willingness to have a framework in place. It's easily shot down if you haven't had that. And I think so get your basics right, is what I say. Get the basics right. Make sure you have your compliance obligation, which there are many. It's a huge act. Make sure your subject access rights, your ROPA are in place, your and updated, all the sort of basic things that you'd expect. There are nuances to data protection. There are data protection impact assessments about high risk processing, all these different things that can go off to a tangent. But actually, what you really need to have is to make sure things like a DPIA, have you got your triggers in place? If you haven't got your high risk sort of filters in place, if you don't know when that might be likely to require that, then you're on a hiding to nothing. If you haven't done one and something happens as a result of high risk processing, really the regulator's looking at you saying, where were your filters? Where were your risk triggers there? Where were your, if you can almost kind of leave yourself on a hiding to nothing in terms of not having the very basics that you'd have for every other, for tax law, for health and safety, for all different types of laws, you'd have all these things in place. Now, the evolution of GDPR has been, what are we talking, 7 years, six, 7 years. Now, I would have expected, personally, as a practitioner, Sylvan, that things would have evolved more than they have in terms of internal kind of awareness about the risks and the sort of the need for these things to be in place. And I think there's work for certain companies to do. Not necessarily new companies that are just formed, but companies that are established. I think once you realise that there's a necessity to comply with the law and have a basic framework in place that you're building upon continually. You need to be able to demonstrate continuous compliance and sort of evolving compliance. If you haven't got that, that's kind of a really key takeaway for a regulator that, like you're not doing DPIAs or you're opening a DPIA, putting your name and address on it, name and email address, and there's no more information on it. And then you're submitting that to the regulators. We opened DPIA. Well, you really didn't, did you? You just ticked the box, or you tried to tick the box.
A very hypothetical question. So if you have one of these cases coming in as a regulator, and you see like, okay, this company really doesn't have their ducks in a row.
Mm.
They don't know what they're doing. Of course, that's going to raise a couple of eyebrows. You may look a little bit deeper than you would in a company where say, okay, well, it's a great report, that's precise, etc. But if it's clear that it's not, then is there still something that a company can do? Does it make sense for a company to then say like, okay, in the weeks after, let's clean up shop, let's make sure that we
Absolutely.
that we go
Absolutely.
in,
Yeah.
or is it something like for you, it's like, well, too little, too late, too
No,
late?
not at all. I think that's case specific as well. I think it'd be wrong of me to say you wouldn't take action. There was a breach in Northern Ireland where they breached all of the police officers in Northern Ireland details. Now, that was a human error. That was like a small kind of, it wasn't as a result of necessarily a hack or some sort of IT failure. It was a human error thing, but the impact was so great that they had to take action, right? So you can't not say that the severity of the impact and the scale of the impact won't be so severe that you might need to take action. However, you do look at companies. I don't think as a regulator you want to put any company under the sort of into insolvency, right? You don't want to give them a fine. You understand that people are generally trying to kind of run their companies in a correct way. They're trying to conform. That's my default position. That was my default position. However, when you have sort of blatant disregard for any kind of especially if you've got a DPO, and you don't have any kind of framework underneath you, it does raise the sort of eyebrows that you kind of are you're trying to pay lip service to it. You're kind of not really. I don't think there's definitely a road to sort of redemption, especially if you show what work you've done to contain a breach, what work you've done to mitigate a breach, what work you've done to engage with affected data subjects, people that might have been affected. I think the key thing there is that, you know, if you have to come to a regulator and say, oh, this happened, and then the regulator has to tell you, what impact that might have on a data subject, you've gone wrong, right? So you really should be at the point where you're able to assess that and you're able to assess detriment and harm to people. You've gone out before, you've gone out to people that are affected as soon as you possibly could have done. You've gone to the regulator within 72 hours, whenever you should have done. If you're waiting for direction on that, I think a regulator would look quite dimly on that.
That makes a lot of sense. Absolutely. My next main topic that I wanted to bring up and put on the table is how to effectively collaborate with regulators on
Oh,
in particular incidents, right? So when does it make sense to involve the regulator, even if it's
mm,
not directly a breach,
mhm.
but there may be an incident or maybe something else happening? When would you advise to, reach out to the regulator for
Sure.
different matters?
I feel I've probably got two answers there, someone. I think what what would be the harm in having a positive relationship with your regulator prior to any sort of breach? So what would be the harm in, engaging with forums, engaging with kind of regulatory kind of initiatives that you could engage upon? Why wouldn't, if you had a function that did data protection for you, then why wouldn't you be engaged in that? And I would encourage that. I think that would be good for you if you then became in a remediation scenario that you had already actually engaged the regulator on positive initiatives, and rather than kind of trying to trying to necessarily avoid that, or not even avoid that, but I think it'd be positive engagement is great. And I don't just mean on reporting breaches that may or may not need to be reported. I think it'd be good for companies to actually see that privacy is a kind of business winner as well, rather than it necessarily being a blocker or compliance step or something that kind of is another onerous sort of bureaucratic sort of compliance, yeah, step, I suppose. Actually reach out to your regulators, find out what's new, find out, keep abreast of all the alerts from regulators, make sure you have all that information. The second part of the question, I think Sylvan was probably about when do we engage with the regulator if something goes wrong. Was that kind of the second part?
Correct. Yeah.
Yeah, sure. So I think we spoke about it before. Generally, I think it's a good thing to understand. I'll be honest with you. There are companies out there that not even aware there's protection regulator, right? So things go wrong that don't even factor into a company's kind of vision to report, right? So, it's a good thing when companies do report. I think it's important to know whether you're asking for something like advice or whether you're reporting something. So, don't necessarily reach out to a regulator with I've got a friend, right, that this happened at their company. It's if you're reporting something that's happened to your company, be really factual about that, right? Not like I knew this guy once that happened. This happened. Just say it's our company. This has happened. Or either report a breach, right? So I think it's really important to feel like you can engage with regulators, but without kind of fear of reprimand, if you like. So reach out. What I'd also say as well is that in terms of legal risk, in terms of regulatory risk, which happens all the time in businesses, right? So every time there's a regulatory risk in a company, we'll go to the lawyers, or everyone will go to the lawyers. The lawyers might say, actually, this is although it's commercial, it's outside of our scope for our advice. So we'll go out to external counsel. Now, I would liken tech GDPR, another, not to give legal advice, but I'd liken that sort of that framework of getting a second pair of eyes upon a breach or a high risk personal activity, as a similar thing. Now, companies do that all the time. It's very normal behavior for a company to go out for external counsel on a particular issue. It's not necessarily the same for data protection. And I think, it's certainly useful for DPOs, useful for controllers to have that avenue to companies like Tech GDPR that can offer that kind of second pair of eyes, but that sort of third-party assessment of the risk that can actually come back with, not involved in the politics of the situation. This is kind of how we see it. I think that's a really good investment for all companies. I think the more companies did that, I think the less you'd feel the need to report necessarily come to the regulator attention. But also, I think you build a stronger framework if you had that in place.
One of the things that we've seen here and there in client situations is also that there was a certain hesitation to engaging with the regulator at all. Companies do not want to be named, do not want to be
Sure.
mentioned,
Mm.
even for reaching out with a question where we as a consultancy sometimes don't really know the answer. So we'd love to have the opinion
Sure,
of the
sure.
regulator. And we actually found that many of the regulators are really forthcoming
Mm.
and willing to help and open to it if resource allows.
Mm.
Um, but the stance of the companies is very often like let's stay under the radar. Let's make sure that they haven't heard our name at all, right?
Mm.
In
So dangerous. It's
instead of yeah.
such a dangerous approach in terms of, especially imagine a ransomware scenario or something like that. Ransomware, for example. So you kind of realize that at a certain point of that scenario, you realize that you probably should be reporting something to the regulator, but you're kind of gaming the fact that it might be kept a secret. You might, I don't know, pay a ransom in a certain jurisdiction which allows that. Or you might be so scared of the regulatory attention that you don't want to approach a regulator. Now, later, if the data appears on the dark net and people start complaining about you, yeah, you're getting hammered. You are getting, the regulators coming for you, right? Especially because A, you didn't report something you should have done, but also you've got you imagine as a regulator, when you get letters, emails from people that are saying, "Oh, this happened, this happened, this happened, and this happened as a result of it," you need to take some action about that, right? You can't yeah, there's a lot of discretion at a regulator. There's a lot of discretion around use of powers and how you use those. It becomes, and quite rightly, there becomes less discretion when you get more and more reports of people saying that this has happened to them or there's detriment, right? So you could look at a breach where, there's no apparent kind of um, detriment or harm to people. However, you see a really egregious kind of procedural fault that you think, hang on, you really should know that. You should have MFA or you should have this or you shouldn't be sending data like that or there could be a really key point, but actually it doesn't really result in harm to people. However, you might get a less egregious um, a sort of mistake, if you like, or error that results in much more contact with a regulator, and then the regulator's hands are tied. If you've got multiple people coming in, and it's not within a priority area that the regulator sees as being something they need to stamp down on, you're getting hit, and it might be something you've not considered as being a risk at all. It might be, well, we didn't want to automate our subject access request procedure. We'd rather have it online, or and you get 10, 15 complaints about um, subject access requests being late or not being fulfilled properly. The regulators, their hands are tied after a point. They will come to you and say, why has this happened? And if you've got no kind of defensible reason why it's happened, I think sometimes companies can look at worst case scenarios and best case scenarios and get them quite wrong.
I think maybe some of this fear is also instilled by one of the early cases under the GDPR. You may be aware of what I'm getting at. I believe I don't have all the details in front of me, but I believe it was a case in Spain where an online merchant or e-commerce merchant reached out to the regulator and asked the question like, one of my
Mm,
forwarding companies refuses to sign a DPA, what do I do? And
mhm.
as a response, at some point, a fine arrives. I think, well,
Sure, sure,
came
sure.
to our attention
Yeah,
that you don't have a DPA with one of your forwarders,
sure, sure,
right?
sure.
So this, of course, instills a bit of fear. Now, my position on that as a consultant would be that the landscape has evolved. I think this was an early enforcement that may have been a little, sloppy or maybe a little bit too early because transforming a request for help into a fine is of course not necessarily very helpful. Um, how do you see this?
Mm. I think that's really interesting. I think I've come across that directly in terms of being the commissioner in the Isle of Man. So very much the messaging for us commissioner was different to the messaging I wanted to put out there. So people were coming to the regulator and saying, "Well, this is our experience before. This is what we didn't get before, or did get before," and I needed to sort of change the dial a little bit on that. For me, how I wanted the regulator to run, and that's no criticism of the previous people who were in charge of it, but I wanted a different engagement approach with stakeholders. And your stakeholders are your DPOs, your private sector, public sector DPOs, government people, people in general, which is your main stakeholder really is sort of general public, in my view. I think in terms of kind of those test cases, I think they can be quite dangerous, and I think we're our own worst enemies a little bit in terms of not articulating that each jurisdiction has derogations, delegations, and has different risk appetites and wishes to enforce differently. And I think personally, I think the GDPR should have been applied more holistically and more cohesively across jurisdictions, and there should have been kind of more criteria around what regulators enforce with and why. There should be more, perhaps kind of I think probably sort of a sort of case history and more developed and more precedents developed in terms of what you would enforce against. A breach in Italy around kind of cookies, or perhaps cookies is the wrong thing, but subject access might not even raise its head in the UK or in France or wherever. And I think that regulators are looking at interoperability and how they work together and how they kind of formalize more sort of a structured approach. But I think inherently you'll have that difference, and I think that's where I think it's probably a good thing. I think that's where companies can't game the system, right? It wasn't meant to be this way. It wasn't brought in to be different in every jurisdiction. But I think, if you can't really tell whether a jurisdiction may or may not be forcing you, that's probably a good thing if you're looking at it from a data a subject's point of view, rather than, oh, that jurisdiction will do this jurisdiction will do that. Do you understand where I'm coming from? It's kind of, I think the differences aren't great. I think they create confusion. I think there's the EDPB has a kind of role in making sure that the guidance that goes out to statutory authorities is more cohesive and is more joined up. But I think you'll always have those derogations, delegations, which make, and local laws and local kind of customs that obviously sort of reflect on how the law's kind of enforced. But yeah, I think it's interesting. So then I think there's pros and cons to each way. It's sort of augmented really, but I think there's sort of some room to do in terms of having a more sort of cohesive approach to enforcement. I
Mm-hmm.
think, it doesn't help in one jurisdiction you can be fined,
Not at all.
a seven-figure sum, in another jurisdiction you get no further action for the same sort of a breach, right? So I don't think that helps. I think it definitely underscores the need to come out to companies like TechGDPR and get that sort of specialist assistance around breaches, around high-risk processing, around kind of 12 monthly reviews of your kind of framework to get that third pair of eyes or that sort of third party sort of assessment of your framework. But yeah, whilst it's good for us, it's probably not good for companies that are trying to navigate the system, right?
Absolutely. And also like incoherent application of things like the GDPR is of course hugely problematic if you're trying to create a union in some kind of sense. Maybe on that note, is there anything that you can share about how collaboration is as a regulator with other
Mm,
regulators in other countries?
Sally, what I think I probably make clear is that I don't know what the perception is, but regulators talk, right? So regulators talk on forums, they'll talk on in-person forums. Certainly, data protection regulators meet up, they have conferences, they have this, they, but also on a case-by-case basis, regulators engage, right? So if something's happening in one jurisdiction which has some nexus to the next jurisdiction, if you like, regulators will pick the phone up, they'll engage, and don't think you're acting in isolation because you're in one particular country, right? So I think that's probably a good thing for the EDPP side of things. I think it's good that regulators do engage, and there's not some sort of Chinese wall between them. I think they should be able to kind of get in there and discuss information. I've worked on joint investigations with UK regulators in different sort of aspects. Wouldn't want to be sort of going into details of that too much, but certainly those conversations go on. You kind of generally have a broad consensus of the law in those meetings. There's not oh, this happens in our country, and well, in the Isle of Man, this happens, or well, in France, this happens. It kind of, it, if you've got to the stage where you're having a kind of international investigation, the facts are kind of fairly kind of clear around what the nuance is to that law. Now, obviously, there are things that happen in different jurisdictions. You know, you have Ireland, for example, has some huge kind of international sort of controllers that process a lot of information that, you know, there might be a different regulatory framework there than there is in the UK or there is in France or so I think yeah, certainly I've worked on sort of multi-jurisdictional investigations that bring kind of actually with the nuance in sort of different legislation, actually there's generally some kind of a coherence to the outcome that's required or wished for.
Right, and you feel that typically this is like a productive conversation with other regulators, or is
Generally,
it more
yeah.
of a I don't know.
It's not
I could also, imagine it could lead to some conflicts or different positions, right?
sure, it's not a tea and biscuit session. You know, you're very much kind of, especially when you look at sort of regulators that have competing, or it's not necessarily competing, but they have different resources, right? So you look at the Isle of Man has, you know, a fraction of the resources of the UK. However, you're still a regulator. You're still kind of there to provide that service that a regulator there to provide. So you rather have to cut your cloth accordingly in that respect. And I think sort of you could look at other jurisdictions which enforce different types of breaches more prevalently. So I don't know, in Spain, cookie breaches or wherever there were nuances to kind of the sort of legislation. I think it's very much about I think having the interoperability is very much something that's work in progress, and I think there's very much a view to that being kind of more of a strand of work that needs to kind of happen and actually take place. There isn't huge generally. If you've got to the stage where you're approaching another regulator, it's kind of quite there in black and white, really, while you're doing it. It's not really that nuanced that you have to argue points around. Hang on, it's you know, it's this point or that point, which may or may not be brilliant. It's more about jurisdiction and kind of primacy, really.
That makes a lot of sense. Absolutely. Let's move to our last larger discussion topic about complaints by data subjects.
Sure.
So I think that's another avenue where many companies sometimes they receive already a request from someone that they may not have answered in time, or
Mm.
they may argue that well, you don't have the right to deletion because of this and this, and there's a fundamental different understanding between the data subject and the controller. So what happens if data subject files a complaint with the regulator? How does such a process look like?
Sure.
Maybe you can talk a bit about that.
Sure, absolutely. I think in the same respect of, I'd say the breach hotline or in books or however you want to term it, you know, data subject complaints are kind of, for me, they were handled in the same sort of time frame. Like we would look at them sort of straight away, really within, you know, reasonable, definitely the same day, you know, looking at perhaps within the hour, assessing risk and detriment. I think if you're a regulator, kind of data protection complaints from people are really your bread and butter, right? That's why you're there. That's what you're there to do and protect people's rights and freedoms. And whilst we aim to kind of make sure we have a minimal impact or as minimum impact on business as possible, you know, really we're there to make sure that people's rights are upheld and enshrined and enforced and all those good reasons that you're regulators. So definitely looking at complaints. I think what I'd say from a company perspective is don't try and assume you know what's at the regulator, right? So don't think you've had one complaint about your subject access request process that a regulator might not have had 10, right? So if you're looking at that from a perspective of risk as a regulator, you're thinking there's a systemic problem with this company with how they deal with. If you get one report, the company might be only approached for a complaint by that one person, but there might be 9 people behind them that didn't bother because the company was so, you know, ineffective that they didn't bother to go to the company to complain. They went straight to the regulator. And now, as a company, you'll never know that. And what I mean is what I mean by that is take those complaints really seriously. Take them like legal complaints. Take them as if they are something that really needs to be expedited. Don't give them a notional, oh, we'll get back to you in 3 months or this or that. Make sure you investigate it, make sure you put it right. And actually, I think that the key there is you'll never know what's on the other side, right? So by not really responding to a complaint properly, you're gaming the sort of regulatory risk that you have because there might be 50. It might be a marketing exercise where you've used a cookie or something you shouldn't have used, and people are complaining to the regulator. Why is this? Why is my data gone to this company? Now you won't know about all those complaints. You'll know something's gone wrong, but if you don't do anything about that upon one complaint, once the regulator comes knocking and saying, "Oh, we've had 55 complaints now of this," um, what have you done? And if you've done nothing since you should have done something, then it kind of shows a little bit of a kind of lack of, well, I say lack of respect. It's lack of adherence, isn't it? It's just kind of a malaise towards the sort of law, really. It's like, well, and I think what you need from companies when there is a breach or remediation scenario is that it's really taken seriously. There's remediation put in place. There's resources put in place to it. There's extra things that are put in place to change processes that aren't really effectual. It's very easy when you get the audit trail back in a breach scenario to look through it as a commissioner or a caseworker or a case manager to go, well, that clearly didn't happen. That didn't happen. That didn't happen. Well, that didn't happen. And then you're in trouble, right? That when there's sort of clear neglect for your obligations or any sort of observance of a mistake that might be within your sort of your framework, then that's when regulators kind of really take a dim view. Is that really it took us to come to you with 55 complaints or 60 complaints for you to respond to this one correctly. Now, you should have done this, 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 and this. And that's when different regulators will take a more punitive view as well and will find straight away. I know, you see, I think that it's interesting, Sylvan, isn't it? You look at case law every month, probably, and you look at the spread of different fines across different jurisdictions, and you think, oh, well, that happened in Austria, that happened in Belgium, Estonia, da, da, da. And you kind of hope that there's some sort of practical application of that across jurisdictions because you'd like to think they become test cases. But what I'd say to companies is that you game it in one jurisdiction or read that and think you can't do that or can do that in one jurisdiction and at your peril already because the regulator will take action and they will come and sort of knock at the door or send the email that says, well, produce me your remediation scenario. Well, what was your action plan? How did you change how you collected information? Show me your records of processing. Show me your subject access procedure. Show me your incident response procedure. These things happen. I've issued them, so I know it happens.
Right. What I've seen as well, and I'm sure you came across this, that maybe a customer or a former disgruntled employee would actually use a complaint to the regulator, or maybe first a
Oh,
subject access
sure.
request and escalate as a complaint, just because they're like unhappy with any other practice
Hmm.
that the
Yeah.
company is engaging in. Have you come across like
Yeah,
very
a
clear
lot.
cases of this,
A
and
lot.
and then how do you deal with that as a
A lot.
regulator?
I'll tell you, I'll give you two sides of that. I've come across it as a DPO, which is a real, someone's been really lawfully
Oh
kind of
yes, yeah, me too.
dismissed of. They've done this wrong, they've done that wrong, and every lever and every clutch is being employed by them to kind of, stop they've tried employment tribunals, they've tried this, tried that, tried this. The last thing they could perhaps do is an employment appeal or something like that, and they need evidence of this. What I'd say from a regulatory perspective is you can't deny a response. You can't deny a response because of someone's kind of perceived malice or malign intent or however you might see it as a company. That's a company risk thing, right? So that's an issue for you as a company is your defensive position in legal proceedings. That's a very different thing to honoring someone's data subject access rights. And I would say even more so, go at it, make sure you honor them. Don't look for kind of and I've worked on very high risk, complicated DSARs that have rested on a $3 million sort of litigation scenario, Sylvan, where a company was suing someone, and the crux of their defense was based on what they might get from a DSAR, and actually honored the DSAR correctly, really went belt and braces, invested. It cost a lot of money to process the data in the DSAR in the way it did happen, but actually the complaint fell down and there was no complaint against the company afterwards, and or actually they dropped the litigation to
Mm.
stop the £3 million litigation against them. So it's kind of I'd see them as different things. Yes, they're potentially annoying. Someone's kind of going out of the way to perhaps cause you a nuisance or annoyance, or it's written in a certain way which might be perceived as being rude or abrupt or blunt, or how dare they say this? Actually, look at it as a subject request. Take the emotion out of it, fulfill the request, or don't fulfill the request. Have your evidence base of why you don't fulfill the request. Have your evidence base as to why you might need to extend the request, right?
Mm.
I think there's good and bad examples of everything. I think if you have a consistent approach and you have a methodical approach, take the emotion out of it, take the sort of emotive side out of it, explain the risk to the company of not doing it correctly, right, and not fulfilling the request, which isn't. It's not an email. It's not just an email asking for this. It's a subject to request. It's a legal kind of requirement that you're there to fulfill. Whether you fulfill it or not, whether you actually disclose or not, you need to fulfill the request, right? So I think it's important for that not to get caught up in too much in internal litigation, internal kind of HR spats, or whatever it is when someone leaves, or notice it as a separate event and actually kind of see that as a compliance requirement or obligation that you need to fulfill, and really kind of try and. It's hard sometimes in lots of companies, but try to sort of take the emotion out of it and look at it
Hmm.
as something you need to properly sort of assess within the time period.
Right. What is then the action list, right? So what does a regulator go through? So what I've seen on my side is like, okay, maybe there's first a subject access request towards the company. There may be a lack of reply or unsatisfactory
Oh,
reply, and then it may be escalated to the regulator. And then the next step, what I have seen is typically a letter with a number of questions from the
yeah,
regulator.
yeah.
Is that
Yeah, very
what you
typically.
would do as
So,
well?
as a regulator, you're not necessarily trying to enforce in every circumstance. It's very expensive to enforce, and it's very time-consuming to enforce. Doesn't always sort of drive up contingent compliance. Doesn't always make people comply more if you enforce more. It does in certain circumstances, but where there's been a mistake or where there's been an error, you aren't there to jump on someone's grave, right? You aren't there to kind of, we're not there to punish businesses and make sure, we're there to hopefully make sure businesses thrive in the best way possible whilst honouring kind of people's rights as data subjects. That's how I saw it anyway. And it wasn't about kind of how can we inflict sort of burden upon companies. It was more about how can we lift that? How can we make that easier, but also whilst kind of maintaining and increasing standards. So I think one example I'll give you is, and bear in mind the things that tend to come to a regulator aren't that nuanced really. Well, they weren't in my experience. They were quite blatant, either one way or another, kind of courses of action. The company had done this wrong or they hadn't, and people would write in and not really know their rights, but they'd kind of get it wrong, and you'd have to go out back to them and say, actually, they've done it correctly and done this properly. I think one example I was a large insurance company was that's all I'll say was their default position was to extend a subject access request straight away. So someone would put a subject access request in, and by default the email that went out kind of once you read through it, said basically we've got 3 months to do this, right? Um, Upon the 28 days, we've got 3 months to fulfill this. And I was reading out this is just like blatantly wrong. Like, for a large insurer, a global insurer, to be
Mm.
kind of putting out that they essentially got like 4 months to fulfill a request. So everyone that ever put in a request to this company, which was large, was getting that response back, which to me that was like systemic kind of misapplication of the law. It was a misapplication of it was a fundamental breach. To me, it was like, well, why should you breach everyone's right to have a certain amount of information within a certain amount of time just because you can potentially employ an exemption in urgent circumstances or in certain circumstances? Why should you then have 4 months to do that? Why should you think that? So there are examples where I can understand where companies try and exploit opportunities within law. I think that's an example of, yeah. blatantly, if that gets to the regulator, you've extended it straight away by the fact you could possibly extend it after a month. That's really wrong, right? You shouldn't be going out to people saying expect a response in 4 months, which essentially is what the letter said. Now, there are nuances to it. I think people tend to, going back to your employment scenario, you do tend to get some very irate inquiries into regulators around subject request responses or companies' approaches with them. And I think you kind of have to boil that down to what the facts are really, and distill from the employment law stuff and then the things that have happened within the job, actually what's gone wrong. Sometimes things aren't subject to a legal test in terms of privacy. Sometimes they're, they're fulfilled within the legal basis. So, it might be
Hmm.
contract of employment, the things that there aren't really breaches apparent because they, the company's kind of stood up to the legal basis that they've used. Other times not, and I think it's a nuanced position. I think certainly reach out to us, Tech GDPR, if you have high risk or any sort of DSARs that are kind of I wouldn't say an issue, but they're always time bound, right? So they're always people have always got a day job to do once they get these, and even if you're a DPO or whoever you are processing the DSAR, it's very nice to reach out to a company to be able to say, look, these are the facts we've got. This is all the information, and to have NDAs in place and to get that sort of third party to come back to you can be really, A, time consuming, can definitely save your company money because if you get sued in the wrong circumstance because of DSOC, it can lose a lot of money. And I use that last example where they could have lost $3 million. So yeah, reach out to us and
Hmm.
we'll lift that burden for you and we'll come back with a good time frame. And I'd also say on that respect, so maybe beware of beware of false imitations. There are a lot of companies out there that offer a lot of data protection services. I've used them previously at DPR. I've used different ones where I've really, sort of wondered why I did that or wondered why I had faith in it working. I certainly can speak for Tech GDPR, Sylvan, and the team there. You've got a really thorough kind of multidisciplinary team there who are going to give you really timely input and a proper service. So I can't speak highly enough of them.
Thanks. I definitely appreciate that. I think that's also what we've seen, right? That we can add a lot of value to these kind of specific cases if things heat up or by even taking an outside perspective on a certain case and just looking at the facts because that's what we need to do. And I think you rightfully mentioned that you need to leave emotions out of this, and sometimes this is very almost personal to the people that
Hmm,
are
sure.
dealing with it, right? Um, Maybe what we can round up with, we're almost at the top of the hour, is
All right. That was
maybe
quick.
it did, right? I think we need to do more of these sessions. It's
Sure, sure,
uh,
we'll
it's
do, we'll
it's
do.
it's 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 good fun.
Happy
It's
to
nice
take
to
questions as well. And if anyone's got questions or
yeah,
suggestions or whatever, I'm happy to,
right, right.
Sylvan. I'm sure it might be thought-provoking for some people. Even if people want to take offline, have meetings, whatever,
Mhm.
we can set that out, right?
Right. Maybe to close with, Stuart. So we
Mm.
had a few questions. I think the one from Joao we addressed in the beginning. My colleague Alex also came up with a really good question, which we kind of like answered in like during the conversation in different ways. So I didn't want to service that again. Maybe to close up, I'm curious about what would you
Mm.
like to work on? What is your passion? What are you looking to bring to the team at
Sure,
TechGDPR, and how can you add value for our customers?
sure. I think it's two-way, right? So I looked at your offering, I thought, great, I want to work with those people, right? And I looked at a lot of different companies, and I looked at a lot of different models. I know a lot of different companies. I've engaged with a lot of different companies before, but didn't really feel the sort of wish to reach out like I did with you. And we had some early conversations. I really liked our conversations. We sort of met at the same sort of level of kind of understanding or kind of outlook, I think, in terms of privacy and data protection. I think for me, I'm technology crazy. I love technology and I love the advancement of technology. I love um, to try and kind of understand how sort of advances in technology can kind of come back to very often regulations are brought out at a certain point in time. Technology soon supersedes that, and the technology becomes far more complex than the legislation is allowed for. Now, I think that's an opportunity for companies, but also I think there's an ethical and moral kind of opportunity as well to say, all right, we won't run too far down that road. We'll keep within the sort of frameworks of this framework until such time as it changes. I think with the AI laws will change. I think there's so many things that are on the horizon in terms of things that interact with privacy. There's DORA, for example, if you're a financial services company within the EU, meeting one of 21 different sectors, industry sectors, you're in scope of DORA, and you have a whole set of responsibilities that are now or will be incumbent upon you in what, a month's time, I think, Sylvan. I think January 17th, I think is
Right.
the
Exactly.
go live date of DORA. And we have a sort of gap analysis kind of function that we've developed at TechGDPR where I think you're going to need to be able to demonstrate or even have faith that you can describe. You have a DORA project in the background. If you don't have everything in place, you need to have a DORA program or DORA project in place. Now, if you haven't started that, that's probably an issue for you. If you're within one of those 21 sort of different industry sectors, and I'd say reach out to us. We can certainly help you kick that project off. It's very much a internally decided upon approach in terms of decisions that take place, but we can certainly guide you and sort of help with the gap analysis side of implementation there. I think, yeah, that interests me, Sylvan. I think the advancements in technology interest me. So they do as well, the application of the law and regulation. And I think I'm keen to work with businesses, especially tech sort of companies that are ever evolving in terms of trying to push the envelope, if you like, and make sure that they're on the right page and they don't sort of fall foul of the law and sanction or scrutiny that might kind of undermine their model.
Brilliant. Yes, no. So I think I'm super excited to have you as part of the team
Thank you.
to have you join on helping companies set up processes, support the setup. I think if there are companies that may be having some issues or potential challenges with the regulators, you are perfectly positioned to support them in that journey as well. And
Oh,
also with your interest and experience in DORA and the work that you've done there already. I think that's super valuable. So very happy to welcome
thank
you
you.
as a
Oh,
senior
yeah,
consultant
thank
to the
you.
team.
Thank you.
With that, it's top of the hour. So thank you so much again for joining us,
Oh,
and for all the viewers. I would say thank you so much for
yeah, thank
attending
you.
this session. There's a possibility also to work with Stewart through TechGDPR. So if that's something that you would be interested in, feel free to reach out. Stuart, again, thank you so much for your time.
Lovely. Thank
Looking
you,
forward
Sylvain.
to continuing this in the future. And
Most definitely.
um, yeah, thanks everyone for
Thanks for
watching.
everyone.
And
Thanks for tuning in. Thank you.